The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. The next case is State versus Ditenhafer, and we will hear from the appellant.
Good morning. May it please the court. My name is Jarvis Edgerton, and I represent defendant appellate Ms. Mardi Ditenhafer. I want to begin by alerting the court to the possibility I may lose power during this argument. It began flickering in and out this morning, but it seems to have stabilized. I believe the issue is construction nearby. Given this concern, I'd like to make 2 points right away and then present my longer form arguments. The first point is articulated in the dissent, that being the fact that all the allegedly obstructive acts in this case are valid exercises of defendant's constitutional and parental rights. This should be a matter of concern because the obstruction indictment here amounts to improperly punishing defendant for legally exercising her rights as a parent and citizen. The second point I want to make is argued in and defendant's brief. That being, there is no substantial evidence here sufficient to support a jury determination that defendant, during the relevant time frame, acted with any intent to deceive or defraud investigators about the existence and/or details of CD's allegations against William Ditenhafer by denying access to her daughter. Absent such evidence, there's no basis for the instant felony conviction, obstruction conviction. Now for my longer form arguments. Is it ever a crime to assert your parental and
Excuse me, counsel. I didn't hear rebuttal time. How much are you trying to reserve?
10 minutes. That's what I'm shooting for, 10 minutes, sir. Justice.
Okay, thank you.
Is it ever a crime to assert your parental and or constitutional rights? The dissent opens its analysis by correctly noting defendant in this case was under no legal obligation to perform any of the actions she allegedly obstructed justice by failing to do. Absent a warrant or non-interference order, defendant was under no legal obligation to provide investigators with any access to CD at all. Thus, until such a warrant or non-interference order was applied for and secured by law enforcement, all access to CD by investigators was via defendant's consent. And consent she did. As also correctly noted by the dissent, defendant voluntarily transported CD to and from interviews with social services and law enforcement. Defendant voluntarily consented to entry into her home by both social services and law enforcement for interviews of CD. Indeed, it is undisputed that defendant granted law enforcement and social services actual access to CD every single time they asked for it during the relevant time frame. So where's the crime? Much less the crime done with intent to deceive and defraud. The majority, in all seriousness, the Court of Appeals majority, in all seriousness, points to how close defendant sat to CD during an interview as an actus reus justifying this felony obstruction of justice charge.
Mr. Edgerton, let me interrupt you just to make sure I'm understanding the nature of your argument. The issue before us, I believe, is simply whether there is sufficient evidence to support a finding of an intent to deceive.
Yes, that's correct.
The issue of whether the defendant was guilty of some version of obstruction of justice has already been resolved, hasn't it?
It has been, yes.
So we're not talking about whether your client obstructed the officers. We're talking about what was the intent with which she did so. Is that right?
That is correct.
How do we go about determining that?
Well, my understanding is it's a fairly that aspect of it is a straightforward insufficiency of the evidence claim.
So we basically look at all of the evidence and see, based upon analysis of the evidence, if there's any of it would tend to support a finding of intent. The state wins. If there isn't, then either.
Yes, if there's any evidence that supports the notion, the conclusion that during the relevant time period, Mardi Ditenhafer acted with an intent to deceive or defraud law enforcement by denying access to CD. The reason I bring up this other stuff is because, as noted by the defense, it's the exact same evidence put forth to support both the misdemeanor obstruction of justice charge and the elevating the factors that elevate it to a felony obstruction of justice charge. It's
now,
the same.
In making the determination that we're supposed to make here, we're not necessarily bound by your client's statements. We're supposed to look at everything and make whatever inferences are appropriate from the evidence. Is that right?
Absolutely. But my client's statements came into evidence through the state. It is my client's statements are the state's evidence.
Let me ask you a quick follow-up to Justice Irvin's question. We do look at this evidence in the light most favorable to the state at this point, don't we?
We do. And it is defendant's position that even with that favorable standard of review, the evidence in this case doesn't even come close to supporting the inference that the Court of Appeals majority claims that it does. The reason I bring up the stuff about the fact that everything she did was actually valid exercises of her constitutional and parental rights is because that really does present to this court a question. It presented a question at when the evidence for the misdemeanor obstruction of justice charge came through, and it's still a problem here because that same evidence the state is attempting to use that same evidence to elevate this case. And my point just simply is, does this court really want to get in the business of punishing people for exercising their constitutional rights? Because that's exactly what's happening here. Absolutely.
Let me jump in and ask you about one of the things the Court of Appeals points to is that the defendant sought to constantly influence her daughter's statements in the interviews by verbally abusing and punishing the daughter for the statements she was making. Are you including that kind of conduct in protected constitutional parenting that you're talking about?
I'm not aware of any evidence where she verbally abused her daughter. As I read the majority opinion, they're saying that she talked over her daughter when investigators asked certain questions. She jumped in and answered them. They're saying that she sat too close to the defendant. They point to the fact that she had her hand on defendant's thigh during the interview. That's what I understand the evidence the state is putting forward to be. At least that's what the majority says, and it's the Court of Appeals majority says in its opinion. As for I believe the stuff you're talking to more relates to the defendant allegedly trying to convince CD to recant. As the dissent correctly notes, that was the subject of a separate obstruction of justice conviction that's not at issue here. But that evidence has been used already to support an obstruction of justice charge, so it cannot be used again. And the dissent makes this point. So I believe that evidence you're talking about, if I understand what you're referencing correctly, would be evidence that related to that separate obstruction of justice charge. And I agree with the dissent that it can't be used here because then you're just double punishing her for the same thing.
No, I'm looking at the part of the majority opinion that's on page 13 of the slip opinion that indicates that her argument on appeal that she was acting in service of the truth is inconsistent with evidence summarized below, and the things that I mentioned to you a few minutes ago are included in a list of things that the Court of Appeals refers to as indicating that she was trying to hide the truth.
Yes, you're talking about where it says the evidence shows defendant believed the daughter may have been abused by someone?
No, down near the bottom of the page that
Okay.
Where they listed she remained within hearing distance or was present in almost every interview.
Let me interrupt.
Messages.
Okay, let me interrupt. That's just not true. The record shows that there were multiple occasions where defendant voluntarily allowed authorities, social services, and law enforcement to speak with CD while she was not present. She was not in the room. She was not within hearing distance, and this happened multiple times. So to the extent the majority is trying to assert that defendant was always present to interfere in these interviews, that's just false.
Wasn't there also the aspect, though, that the mother wanted the daughter to text her or otherwise communicate with her whenever there was that presence of the authorities to talk with the daughter outside of the mother's presence?
I'm not aware of that specifically, but even if that's true, that's simply a valid exercise of her constitutional rights. The CD is her minor daughter, and any access to law enforcement, short of without a warrant or a non-interference order, had to go through this defendant as the mother. She was well within her rights to say, ask her daughter to text her if law enforcement or anyone else was approaching her, and she had concerns about that.
But in terms of what you're saying, though, about the liberality of the mother allowing the daughter to have this type of contact with law enforcement, even outside of her physical presence, nonetheless, the mother still exercised some degree of presence, even if it was constructive, in terms of having the daughter to remain in contact with the mother concerning any interrogation by the authorities.
Yes, I just don't see that. Defendant does not see that as a crime. Defendant sees that as a good parenting. She's staying on top of what is going on here. It is a stretch of conjecture and speculation to turn that into an intent. On its face, it's just simply a mother keeping track of her daughter. And I understand under the circumstances, people can speculate into any sort of intent in there they want, but to convict her of a felony obstruction of justice conviction, there has to be substantial evidence. It can't just be, well, she asked her to text, therefore she must be intentionally trying to circumvent the investigation. I think that's a step a mile too far based on that evidence.
Well,
is it your contention that the mother had, I'm sorry, Justice Hudson.
No, I'm sorry. I thought you were done. Go ahead.
Oh, thank you for the permission. Counsel, are you contending that this constitutional right of a parent has no boundaries when it comes to the search for the truth in terms of the investigation of a crime that's been alleged?
Oh, absolutely not. The boundary is when the state comes back with a warrant or a non-interference order. Then all of a sudden, it's not a valid exercise of her constitutional rights. It's a denial of judicial process. But the state didn't do that here. What they did is they came in, they asked her to do a bunch of stuff. She asserted her rights. They didn't follow up on it. They eventually ended the investigation. And then later on, they came back and turned it into 2 felony counts of obstruction of justice.
Is your contention?
Can I ask my quick
Yes,
question?
okay, sorry.
One of the bits of evidence that the Court of Appeals majority points to is that the therapist, the daughter's therapist, testified specifically that the daughter said that the defendant asked her to lie.
That
seems like in a different category.
That statement, what she was saying was, the evidence unerringly points to the fact that defendant never did not believe the daughter's accusation during the relevant time frame. After the relevant time frame, she walked in on William and CD having sex, and at that point, obviously, she did believe it. And at some point soon, I'm going to read that because it's relevant. But during the relevant time frame, she did not believe it. I'm sorry, I lost my track. Justice Hudson, could you ask that question again?
Oh, I was just asking whether the testimony from the therapist.
Yes.
That
okay.
About
the lie.
Daughter said that
yes.
she wanted to lie.
What the daughter was saying is, my mother doesn't believe me. She wants me to recant. She believes a recantation is the truth and that I'm lying. So when the daughter said to the therapist, my mother wants me to lie, that was from the daughter's perspective. From the mother's perspective, she wanted her daughter to tell the truth and stop issuing false accusations against her husband. Because her husband, William Ditenhafer, denied all this stuff to Mardi, and Mardi horribly, unfortunately, believed William over CD. So that statement from CD, my mother wants me to lie, that's not evidence of her intentionally promoting a deception because, like I said, the evidence unerringly shows that Mardi just didn't believe the accusation was true. Now, if Mardi believed
I understand that it could be interpreted in the context in which you're framing it, but the evidence is that the therapist said that her mother asked her to lie. And that was favorable to the state. Doesn't that support the intent to deceive aspect of this offense?
You can't take that statement out of context and then hold it up to mean something that within context it plainly does not. I mean, any valid conflict in the evidence should be resolved in favor of the state. This is not a valid conflict in the evidence. That same therapist also said that Mardi Ditenhafer did not believe the allegations. The very same person who y'all are getting that evidence comes from also said that Mardi didn't believe it. So the question is, if you believe that Mardi believed what CD's allegations during the relevant time period, then admittedly defendant loses. But there's just no evidence to support that conclusion. 3 state's witnesses, and this is the state's evidence, not defendant's evidence, 3 state witnesses testified point blank, Mardi did not believe the accusations. No state witness testified to the contrary. There is no conflict in the evidence on this point. The state's evidence unerringly shows Mardi did not believe the accusations during the relevant time period, and 0 state's evidence shows otherwise. And I think that's the core of this case. Now, in the opinion, the state or the majority talks about stuff that happened outside of the time frame. That, you know, after Mardi walked in on William and CD having sex, they say some things she did afterwards can be used to infer an intent back in time. That argument completely ignores an intervening factor. The state's evidence about what happened when Mardi walked in on William very clearly shows that all the way up until that point, Mardi did not believe the accusations were true. And allow me to briefly read from the transcript the state's evidence about what happened when that happened. Okay. And so he was on the bed when you came in, question. Yes, this is CD is testifying. And what did he ask? And you did what he asked you to do, yes. What's the next thing you remember about what happened? CD's testifying. I zoned out and I remember him saying, oh shit. And then I'm like, what? And I turned around and Mardi is standing in the door. So, question. And what happened next? Answer. We have a shower room that connects both bathrooms. So I ran into the shower room through their bathroom. Mardi goes into the bathroom. I think so that she could see both of us. And she asks, what's going on? What is this? You know, she's pretty upset. And William was like, it just happened. You know, with her allegations last year, I just wanted to do it. I couldn't get it out of my head. And Mardi asked CD, is this true? And I'm just crying. This is just more evidence that Mardi did not believe the allegations during the time she was allegedly intentionally trying to deceive the state about the allegations. So anything that happened after that point, you can't refer back because plainly from that evidence, the state's evidence, Mardi just didn't believe it until she saw it with her own eyes. And so
what's your response to the majority's recount in its opinion that even after the defendant had walked in on her husband sexually abusing her daughter, that the defendant told the social worker Seymour that the defendant had taken action, quote, to avoid any more lies from the daughter, unquote?
Well, I say that that's outside of the time frame. She's not charged with anything that happened at that point in time. And what her intent was after she walked in on William and CD having sex is just completely irrelevant, unless you can use that evidence to come back and say, well, at this previous point in time, that's the intent she had. You can't do that here because of the state's evidence about walking in. It is just the evidence from the state unerringly shows she did not believe those accusations during that time.
But isn't the position also that you're taking that she did not even believe the child after walking in if she says to the social worker that she has had the husband removed from being able to come to the premises so that there would be no more lies from the daughter?
My position is that's completely irrelevant to the charge before us right now. If the state wants to charge her for that conduct, they can, but they haven't, at least not yet. And so my response is that's irrelevant. unless the state can show during the relevant time frame when she allegedly committed these acts that she did it with the relevant intent, then it just doesn't matter. And the state's attempt to argue that these events that happened after William walked in plainly are not evidence of her intent prior to when William walked in, because we have the evidence from what happened when William walked in and what happened before. There's just none of that is evidence of what defendant was thinking at the relevant time. And if you can't show what she was thinking at the relevant time, you haven't made out this offense. The evidence is insufficient. You just can't bootstrap this back in when obviously that assumption of intent is utterly contrary to all the other evidence. Speculation.
So just to make sure I understand your argument, Mr. Edgerton, is your argument, first of all, that a parent has a constitutional right to do anything whatsoever when their child is the subject of a law enforcement or social services investigation in the absence of one of these orders that you...
If the indictment accused Mardi Ditenhafer, defendant, of denying access to her daughter. That's the charge. The charge that the elevating factor is that she took those actions. The accusation is that she took those actions with the intent to defraud or deceive.
Well, but the specific, you a number of times you said something that sounded to me as if you were saying that a parent had a constitutionally protected right to do anything.
No, what I'm saying is a parent has a constitutionally protected right to govern access to her daughter, which is the charge. Now, right. I'm not saying a parent has a constitutional right to knowingly destroy evidence or anything like that, but that's not what she's charged with. She's charged with denying access. That access only occurred by consent.
Excuse me.
In this case.
I'm sorry, I interrupted you.
I'm sorry.
So that's me. That's not you. So I'm still having trouble understanding why this argument is even before us, given that the issue is whether there was an intent to deceive, not whether there was an unlawful denial.
Well, I mean, it's before us because, like the dissent said, it's the same evidence. So it's the same problem. But there's really, I mean, I only bring that up just to give y'all an idea that this case is far more complicated than it seems, and that there's a real serious issue lurking here, that this is essentially punishing somebody for exercising their constitutional rights. And if I may add, this is not the only time that happened in this case. The defense sought the original indictment was one indictment for felony obstruction of justice that tracked boilerplate language. The defense filed a motion for a bill of particulars. The state acknowledged that the original indictment didn't allege any actions really, just boilerplate. So they went back to the grand jury and they came back with not one, but two obstruction of justice indictments. The message the state has sent here is every time defendant exercises her constitutional rights, she gets punished with an obstruction of justice charge. You know, she exercised her constitutional rights to govern access to her daughter, absent a search warrant or non-interference order. She got an obstruction of justice charge. She exercised her right to ask for a bill of particulars. She got another obstruction of justice charge. There's a pattern here. And that's all I'm trying to say. Now, whether y'all make any decisions based on this pattern, of course, is up to this court. I also say that there's zero evidence supporting the allegation of felony obstruction of justice. And that's the argument I principally make in the brief. But I do think y'all should be aware that this is just flat out punishing somebody for legally exercising her constitutional rights. She had a right to terminate the interview. She had a right to prescribe the boundaries of the interview. The interview only existed via her consent. So, like, say you got a police officer.
I know we're into your rebuttal time, but I do want to ask you on the question of what evidence is sufficient to prove an intent to deceive. Does the state have to have some evidence substantial evidence from which a jury could conclude that Mardi knew that her husband was the perpetrator, or should have known? Is it enough that the state proves that she should have known and therefore she had an intent to deceive?
I think should have known, it gets into speculation and conjecture. You know, the state has to present some evidence that, taken in a light most favorable to the state, is substantial evidence sufficient to support a conclusion that she intentionally was trying to deceive or defraud law enforcement. I just don't see how sitting too close to your daughter during an interview, having your hand on her thigh during an interview, or any of these other things the state points to, is evidence of an intent to defraud. You know, every time the state asked for access to Mardi, or a defendant, she gave it. I mean, and the dissent goes through this quite well. There's just the evidence is replete with instances where defendant gave access to the daughter. You know, how can you point to that and then say she's intentionally trying to deceive or hide? If she's intentionally trying to deceive or hide, she sure went about it an odd way. And if I might add, do you know who reported this incident to law enforcement on the day the report first came out? Defendant did. Defendant reported this CD's accusations accurately, fully, completely, without reservation on day one. This is the person the state is saying intentionally hid these accusations, the same person who reported them.
And counsel, while you say that the record is replete with evidence that supports your position, you say that nonetheless, when you're responding to my learned colleague, Justice Hudson, that the instance wherein the daughter told the therapist that her mother had told her to recant and to therefore lie, that as a result, that in and of itself is not enough to get the charge of the felony level to a jury?
Let me be really clear on this point. CD said her mother told her to lie. That is CD's perspective. CD knows her accusations to be true. CD's mother, the defendant, does not. When CD's mother said, I want you to recant, CD's mother was saying, I want you to recant these lies.
But did that come into evidence?
Yes. 3 state's witnesses testified that the defendant did not believe the accusations.
So while I understand your characterization of it, nonetheless, if it is in evidence, are you saying that the evidence is so replete with what is, in your view, supportive of the defendant, that evidence is insufficient because of the weight of the evidence being in favor of the defendant in terms of the volume of such evidence?
Well, I'm saying 2 things. I'm saying the volume of the evidence clearly shows that she was not acting with intent to deceive. And I'm also saying the characterization of what CD said as evidence that defendant intentionally lied is just flat out false. That is not what was said. That is not what the evidence shows. The evidence shows what CD was saying was Mardi, who is wrong about whether these accusations are true or not, is trying to get me to recant. From my position, that recantation is a lie. The question before this court is not what CD intended or knew or believed. It's what Mardi intended, knew, and believed. And there is 0 evidence that Mardi believed that William Ditenhafer committed these offenses. There's just, you know, I mean, the dissent goes through it. I go through it in my brief. It's all there. Now, if you want to take one sentence out of context and say that that's sufficient to convict somebody of a felony obstruction of justice charge, I don't have the power to stop that. But I don't think that statement is anything more than suspicion and conjecture. And I think it's a misrepresentation to call it evidence of Mardi's intent or state of mind. It's evidence of CD's state of mind regarding these charges, not Mardi's. And if you look at where they mention that in the record, I believe it's in the record or whatever, right after CD says that, she says Marty doesn't believe the accusation. So CD literally in the same breath contradicts the assumption that the state and the majority in the Court of Appeals is trying to get people to draw from that. I mean, we can turn our people can be willfully blind to context if they choose to, but that's what would be going on if that bit of evidence was used as a basis to support this conviction. It would be a misrepresentation of the context and the framework in which it came out. I see I'm running out of time.
Thank you, counsel. We'll hear now from the appellee.
May it please the court, I am Sherry Lawrence, a special deputy attorney for the North Carolina Department of Justice, and I represent the state in this case. This court has already unanimously determined that there was sufficient evidence to support a misdemeanor obstruction of justice conviction for denying the Wake County Sheriff's Department, the Wake County DSS, access to the minor victim CD. This court remanded this case back to the Court of Appeals for the limited purpose of determining whether there was sufficient evidence to enhance the charge of obstruction of justice for denying access to CD from a misdemeanor to a felony under NCGS section 14-3 subsection B. Therefore, the sole issue before this court is whether the Court of Appeals majority properly determined that there was sufficient evidence that the defendant feloniously obstructed justice with deceit and the intent to defraud. The Court of Appeals majority properly followed this court's directive by considering the defendant's behavior within the relevant time frame, as well as outside of the relevant time frame, and the majority also considered the surrounding circumstances of that behavior and ultimately determined that the defendant acted with deceit and the intent to defraud when she took actions to deny law enforcement and DSS investigators access to CD. The defendant does not have a constitutional right to break the law and impede law enforcement and DSS investigations into her husband or anyone else. The legislature determined that when they enacted 14-3 subsection B. The defendant's actions in this case established a pattern of deceitful and purposeful behavior targeted at defrauding law enforcement and DSS to end the sexual abuse investigation into her husband and her minor biological daughter, CD. The defendant stated, evidence shows that she stated that she believed her daughter was abused by someone, but still she refused to cooperate with law enforcement and DSS to protect, and allegedly, according to defendant now, she did so to protect her daughter and exercise her constitutional rights, rather than to cooperate with law enforcement and hold the abuser accountable. The defendant's actions and the circumstances of this case show her deceit and her intent to defraud. This court, in its 2019 opinion, pointed out a number of actions that the defendant took to support the misdemeanor obstruction of justice. The Court of Appeals also highlighted that evidence as well. That those same actions, looking at that pattern of behavior, in addition to looking at what the defendant did after the relevant time frame when she personally witnessed the abuser and her daughter engaging in sex, the actions that she took after that are all relevant in establishing her intent. Our pattern jury instructions instruct us on how we arrive at one's intent and what evidence we use to show that. Intent is a mental attitude seldom provable by direct evidence. It must be ordinarily proven by circumstances from which it may be inferred. You arrive at the intent of a person by such just and reasonable deductions from the circumstances proven as a reasonably prudent person would ordinarily draw therefrom. And here, when you look at the defendant's actions that she took, and you look at the circumstances around those actions do provide sufficient evidence of her intent to defraud and deceit.
What's your response to the defendant's position that everything that came into evidence after the husband walked in on, I'm sorry, that the defendant walked in on the husband's act with the child is irrelevant?
The state's response to that is that it is very relevant and that nothing prevents this court or the trial court from considering that and arriving at the intent. Because again, you're looking at the entire circumstances. If anything, those acts that are actually her behavior afterwards, the fact that she actually witnessed the sexual offense in progress after the fact, and it was 7 months after I think the investigation was closed in which she observed this behavior in progress, it actually solidifies her intent in 2013. So if there was any question as to whether she was proceeding with this innocent intent of protecting her daughter and exercising her alleged constitutional right to do so, which we do not concede that she has that under these circumstances, her actions in 2014, once she saw that behavior, it solidified her intent. It solidified that intent to defraud and to deceive. However, prior to even witnessing it, the state's evidence shows that her actions clearly established that intent and intent to defraud and deceit. The pattern of behavior she engaged in.
Sorry to interrupt you, but I just want to make sure that I'm clear. Do you agree that in order to elevate the misdemeanor obstruction of justice to a felony, there has to be proof that she intended to deceive that her actions were intended to deceive law enforcement?
Yes, Your Honor, that she acted with deceit and the intent to defraud. Yes.
And I have always struggled with defraud in this context because it's not clear. It doesn't seem to me she was trying to obtain anything fraudulently from the police. But what I want to understand is whether you agree that in order to show that she had the intent to defraud, that she acted with deceit and intended to defraud, the state needs to have some evidence to show that she knew that William was the perpetrator. Because if she didn't know that, how could she be deceptive about that?
I think the evidence of that lies in the circumstances of her actions, and it's enough for a jury to draw the inference that she did know based upon her pattern of behavior.
Specifically, in the time period at which her intent is relevant here, what was the evidence that shows she knew that William was the perpetrator and she intended to deceive the law enforcement about that fact?
The evidence before the state is all of her actions that she took, beginning with talking for Jane, talking for CD, answering her questions during all of these investigations into this behavior, number one. Then after that, in July, she actually interrupted an interview and abruptly removed CD from that interview once she realized that she wasn't going to recant. It was constant conversation about getting her to recant. It was constant conversation from the defendant as to why she needed to recant. She needed to recant. She wanted her to recant because of the fact that she wanted to maintain her happy life. She did not want her daughter's sexual abuser going to prison. So I think all of that evidence coupled with what happened after the fact that the state's evidence presented on June 21st, 2013, that she actually induced CD to refuse to speak with the officers and the social workers. She then limited their access to her to outside in a rainstorm and to advise them to refrain from speaking with her CD until out at any type of school, and all of the contact would have to be outside of the home. All of those actions put together, they establish, and it's enough for a jury to make an inference as to her intent. It shows that pattern of behavior. And here, it clearly shows, if you kind of look at the timeline of how it occurred, she orchestrated this behavior and she orchestrated the recantation and she orchestrated these meetings where she thought she was going to recant, but she didn't, for the purpose of ultimately achieving what she did achieve in the end on December 18th, 2013, which was the actual closing of the case. And the defendant, I'm sorry.
Well, so what's your response to the defendant's argument that the evidence about her seeking to get her daughter to recant, that she is already found guilty for that behavior, but that actually illustrates that she did not believe that her husband was the perpetrator. And so on the question of whether she intended to deceive and whether she knew that her husband was the person perpetrating these assaults, the pressure to her daughter to recant actually shows that she didn't know her husband, or she didn't believe her husband was the perpetrator.
I would think that this evidence does not show that. This evidence put together, I think you can't look at one piece of evidence solely by itself. When you put all of the evidence together, it establishes her pattern of behavior, and it establishes her plan to defraud law enforcement, which she did. Rather than just having the intent to defraud, she had the intent, and she actually achieved her result by getting him back in the home in Thanksgiving 2013. And her knowledge of the actual offenses comes from her actions, and it's something that can be inferred from her actions, because as our jury instructions guide us, and understand that they're not law, but as they guide us, intent is something that's seldom proven by direct evidence. So you look at the circumstances surrounding it, and the circumstances here consists of her behavior and the pattern of behavior that she engaged in. And let's say, assuming arguendo, that she didn't believe that it was William. However, we do have evidence that she said she believed she was abused by someone. So even at the point that she allegedly believed that she was abused by someone, would she solely tell her just to recant and not to have any access with them and to call me first? Or would she try to find that true abuser? I think that's a big question. And there too, and that goes specifically to her intent to defraud law enforcement away from the investigation into her husband. And it's also relevant to infer her intent and her knowledge that he was indeed the perpetrator of the sexual abuse on her daughter. Because if she was a concerned parent, as she now wants this court to believe, and an innocent parent that was exercising her alleged constitutional right, she would have cooperated with law enforcement, because she's allegedly stated, well, I believe she was abused by someone. So an innocent parent, a mother that wants to protect her child, will not simply say, well, don't talk to law enforcement. They're going to be highly inflamed and highly upset at the fact that their child has been sexually abused by anyone, and they would like to pursue that investigation. However, that's not what we have here. We have something completely different.
If we're entitled, if the evidence that she engaged in the behavior that constitutes the obstruction is sufficient to show intent to deceive, wouldn't there be felonious obstruction in every case?
Well, I think this case is different because we're looking at the circumstances, and it's not just one act. I think it's multiple acts, it's multiple circumstances that I just pointed to as well. And if anything, I would say that her personally witnessing the sexual offense, that solidifies any question that you would have as to, well, what intent was she proceeding with? Because
But that definitely happened after the time period that she's charged with in this particular case.
It did. It happened 7 months after. I think the state's contention is that her actions and her reaction to that solidifies that prior intent in 2013. Now, there's no question that the state's evidence also provides sufficient evidence that she had that intent in 2013, even within the relevant time frame of July 11th and September 1 of 2013, by the actions and the circumstances around the actions that she took. I mean, she constantly told her to avoid law enforcement, don't talk to DSS. In fact, one of her last actions at the end of that, one of her primary actions, of course, she wasn't just I think the defendant paints a picture that she was just sitting there holding her hand on the knee or something of that nature, and she wasn't causing any harm. However, this happened during several interviews. The state's evidence establishes that she talked over her, she answered questions for her, and it contradicts the defendant's argument that she just wanted the truth. She just wanted to protect her daughter. It contradicts that argument now. And it also contradicts her statement to Mr. Karski about she believes that her daughter was sexually abused by someone. So all of that, and looking at those circumstances, I think the circumstances of all of this behavior is relevant. And I think this is important because this is a case where there are multiple actions, but there are also circumstances surrounding those actions. So she did abruptly remove Jane from this interview on July 1st, 2013. However, the circumstances of that show that prior to that, they had had multiple interviews with her and they tried to get this information from her. However, she engaged in a pattern of talking over her, answering the questions for her. And then after that, or a little bit before that, she told Jane, don't talk to law enforcement, don't talk to DSS. So kind of looking at that entire pattern of behavior, looking at the circumstances going on. And in terms of circumstances, there's some additional evidence too, where she continued to try to influence and control the narrative and control what the daughter said, not just by engaging in the acts that the majority sets out as the actual basis of the denial of access, but she did a lot of things to Jane at home. She continually punished and harassed her until she was able to induce and pressure her to not cooperate with law enforcement. In DSS, she constantly called her a crazy and manipulative bee. She told her that she was destroying her life and she was tearing her family apart. She constantly told CD that William would go to jail because of her lies. She told CD that her younger brother, which was William's biological son, would become a drug addict and a high school dropout if William went to jail. So she tried to play that guilt factor on her as well to get her to do what she wanted her to do, which was to recant these allegations, not to recant the allegations and identify the correct abuser. That was not the narrative. Now, I think we would have a different case if that was her contention. Let's just stop telling these lies on William and tell us the truth about who it really is. There's no evidence of that. There's no mention of that at all, that, hey, there's this other person I'm trying to get her. She didn't tell DSS, I'm trying to get her to really tell me who it is. And that would be the most logical thing to do. So she engaged in a lot of threatening behavior towards CD. So I think those circumstances, we have to consider that as well, because all of that is going on during the time that she's taking these different actions of trying to prevent Jane from revealing her and making her statement to law enforcement at DSS.
Ms. Lawrence, I'm sorry, can I stop you there? I apologize. When you use the term relevant time period, are you using that synonymous with the time period in the indictment?
Yes, Your Honor. And I think the defendant's argument is that the relevant time period here for purposes of this is the July 11th through 2013 through September 1, 2013. And we're not conceding that we're limited to that time frame for purposes of intent. I would argue that all of the evidence is relevant for purposes of establishing intent.
Right.
Sorry.
No, I'm sorry. Go ahead.
Go ahead on. I'm sorry.
Now, would time be of the essence for the charge of obstruction of justice, felony or misdemeanor?
No, Your Honor.
Thank you.
No, Your Honor.
I don't want to put words in your mouth. I do want to understand precisely your argument. So I think I understand that you're saying that the incident when the mother found out for sure that William was the perpetrator, saw him in the act, that at that point, whatever happened could either bolster her claim that she really didn't know, or it could bolster the claim that she did know, but she and that evidence. So when she removed the bed sheets, ultimately had them so that they were destroyed, when she did not immediately go to law enforcement or DSS and say, "Hey, you're not going to believe this. I just saw what happened. I was wrong." But she didn't do that. Anyway, all the things at that point that she didn't do would be relevant evidence to what her mindset was 7 months previously with regard to if she knew, she would have acted one way, she didn't know, she would have acted another way. So is that in essence what the state would argue? Did I get that right?
Yes, Your Honor, I think you did basically get that correct. That evidence, while I guess the defendant argues that is outside of the indictment time frame, it is relevant. It's relevant to show, well, there's no question of her intent, what her intent was. And our argument is that there was evidence within that time frame, but in addition to that evidence within that time frame, this evidence that the defendant says is not relevant outside of the time frame because it occurred 7 months after that time frame, that evidence is very relevant to show her intent within the relevant time frame of July 2013 and September 2013, because it basically confirms that she indeed wanted to defraud law enforcement. In fact, she never went to law enforcement on this. Even after observing the behavior of William having sex with CD, she still didn't cooperate. She still didn't engage in what she said was her efforts to protect her child. She still didn't elicit any type of help from anyone. In fact, in May 2014, once she realized that the investigation was open again because the defendant's brother made the report to DSS, she tried to run away from law enforcement and DSS. She turned around in her neighbor's yard as she's coming home because she saw DSS and the lead detective in her driveway. So she knew what was going to happen because she knew and had that intent to defraud from the very, very, very beginning. And it does confirm her actions back in 2013, because keep in mind, she engaged in the pattern of behavior beginning, I think this started somewhere around April of 2013, maybe. And so in July, they had the removal. She removed her from the interview. She consistently induced her to do things and not talk to law enforcement. And then we have him, all of this behavior. She finally wears CD down. She finally is able to get CD to recant. She's finally able to impede the investigation and deny the access that CD has to law enforcement. She then has the ability to defraud because she gets the investigation closed. DSS closed out in December of 2013. And guess what? William moved home prior to that, a month prior, in Thanksgiving 2013. So her ultimate goal was what she told CD every day at home: you're going to ruin my life. You're tearing the family apart. You are a crazy and manipulative beast. She constantly reiterated these things. So she's telling us exactly what her intent is and what she desired. And she accomplished it in 2013. But for Jay Ditenhafer making that report to law enforcement, to DSS, we wouldn't be here today. And at that point, of course, they don't hesitate. They have information that they need. They got it from Jay Ditenhafer, and they remove the children, and take out charges against defendant. And defendant still doesn't acquiesce. As I stated, she's tried to run and tried to tell the kids to run as well. And again, this is not an exercise of her constitutional right. It's not. She doesn't have a constitutional right to impede investigations and break the law. As I stated, her primary objective from the get-go, and the evidence supports that objective and showing that objective, was to maintain her, what she believed to be a happy life with her minor daughter's abuser, even if that subjected CD to continued sexual abuse. So in the light most favorable to the state, there was sufficient evidence that the defendant denied law enforcement and DSS access to Jane, and did so with the intent to deceive and defraud law enforcement and DSS. If there are no further questions, the state will rest on its brief.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Line will be in recess. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court. And thank you, Fred.